titled, borrowing from Walter Burns, Freedom, Virtue, and the Politics of Regulating Pornography. My task is to say something useful about the politics of this matter, and I'd like to approach it a little differently than I did in the paper, at least at first, by addressing what I'd like to call three dimensions which have to be taken into account in the study of any kind of policymaking in the United States. The first dimension is what I call the constitutional. Because our system's not parliamentary, where one body decides policy for the whole country, and one party dominates that body, American policymaking is enormously complex. On the constitutional dimension, there are two great principles of organizing our regime that you know. On the one hand, federalism, on the other hand, the separation of powers. And both have to be taken into account in talking about the politics of public policy making. Does the policy area in question, first question you would ask, fall under the jurisdiction of the federal government or the states? Or since usually both are involved, what elements fall under the jurisdiction of each? In our matter, regulation of pornography generally would fall under the police power of the states. And it typically did, where materials might have been censored or seized or destroyed. The federal role would involve trafficking or commerce among the states, principally, and also the use of the mails. And later, the other instrumentalities of communications, the airwaves. Protecting communities against the harm of pornography, in other words, would be fundamentally a state function. But the federal government could be involved to keep the channels of commerce from growing corrupt or from breeding or spreading corruption. On the matter of separation of powers, among the institutions of the federal government, what's involved depends on the policy area in question. If it were a matter of foreign policy, we would talk about the relation of Congress and the president in talking about any kind of policy making. But here I think the politics has to do especially with the relation of the political branches to the courts, at least in the latter half of the 20th century, as the courts have granted non-obscene pornography constitutional protection. Political scientists now figure that since courts are willing to alter constitutional meaning rather freely, their action needs to be analyzed not by abstract doctrine, or not as abstract doctrine, but rather as a sort of constitutional politics. And in this game, although the courts are particularly powerful players, they don't hold all the cards. So that would be the first dimension, the constitutional dimension we'd want to think about. A second dimension concerns the ideas and interests that are involved in any sort of political area, in any sort of policy-making area. How do these ideas and interests work their way through the constitutional framework? What interests or ideas are involved in the issue in question? For us, the interests would include those who profit from pornography, those who make the products or distribute them, their customers too, at least from their own short-term point of view, they might consider it profit. On the other side, there are the interests of the victims of pornography, whose suffering was described so movingly yesterday, and the interests of the public at large in public morality, which Jerry Bradley described so well in his paper and alluded to briefly in his remarks this morning. Interests are always intertwined with ideas, and in this matter, because shame still attaches to the interests on the one side, and because claims about public interest in moral culture are prominent on the other side, ideas are particularly important. I want to speak about these at some length a little later, but let me just note it here and mention now the third dimension. The third dimension that has to be considered in any kind of policy making, I think, is an historical dimension. Policy is not made on a blank slate, even if ideas about good policy were widely agreed upon. Rather, today's policy options depend on yesterday's policy choices, as any play of a board game is limited by the previous moves. That means that we need to know a little about the history of pornography regulation in America. And in the paper, I go into this at some length. I'm just going to list some of the moments, some of the stages to keep in mind. First of all, pornography was originally addressed through English common law, and as it was brought over and applied in the states, the obscene or the spreading of obscenity being a punishable offense. In 1842, the federal government first got into the act by banning the importation of obscene materials and adding in 1856 the banning of photographs to address the new technology. In 1865, the federal government extended its reach, apparently as a result of the spread of pornography among the troops in the Civil War, to ban the mailing of indecent materials. And in 1873, in the Comstock Act, it included in that prohibition not only obscene materials, but even the mailing of information about birth control or abortion, the matters that were illegal in the states at the time, and lengthened the jail terms and added substantial fines and strengthened enforcement. Another stage worth noting is that in 1915, the courts decided that movies, again a new technology, should be treated as theater and therefore fell within the police power of the state without any interference from the First Amendment or the federal courts. In the 1920s, there came to be a call for federal regulation of movies, and this was fended off by the movie industry hiring the Postmaster General, with William Harrison Hayes, I think was his name, to become their public relations agent in New York, and that led to the development in the 1930s of the so-called Hays Code. It's not an accident that you liked the movies from the 30s and the 40s. It turns out to be one of those probably rare instances in history where setting up a scheme, albeit of privately initiated, but legally shadowed, I guess you could say, censorship probably enhanced rather than frustrated the development of art. 1930s as well, the Federal Communications Act was passed, where the federal government asserted ownership of the airwaves, and in the statute promised free speech over the airwaves and also banned obscene and lewd speech, and these weren't seen as being at odds with one another. In the 1950s, however, the Supreme Court got into the act. Mores were changing. The Hays Code began to disintegrate. And the Supreme Court began to define obscenity and began to protect obscenity, or at least certain kinds of pornography, with the First Amendment. They'd first gotten involved in giving First Amendment protection to movies as well, to adding that technology. And Jerry's talked a little about those issues of the standards and that eventually developed. There's sort of a 20-year period, really a 15-year period, where the courts work out a federal obscenity standard, which has remained more or less in place since 1973. There was also a federal commission in 1970, a presidential commission, which recommended deregulation of pornography, claiming that there were no harmful effects caused by it, but this didn't prove satisfactory to the interests, as you know, and so in 1986, another commission reported, the Meese Commission, which had, drawing on newer research, made somewhat different recommendations. The new development in the 80s, which I write about at some length in the paper and I'm just going to allude to here, was an attempt to pass local ordinances in Minneapolis and Indianapolis and later in Cambridge, Massachusetts, which would redefine obscenity, or rather substitute laws against pornography for laws against obscenity, and would define those as discrimination against women and seek to suppress obscenity using the model of civil rights laws. That the Minneapolis ordinance was vetoed by the mayor. The Indianapolis ordinance passed, but was struck down by the federal courts in an opinion of some note by Judge Easterbrook, and I quote parts of that opinion in the paper. And from thence to at the same time, I guess there was success in suppressing child pornography. It was at this time that attention turned to child pornography, if only because the courts allowed the suppression of that form of pornography. But in the Federal Communications Act rewriting of 1996 was included the Internet Decency Act, which sought to really limit the availability, at least of child pornography or pornography available to children on the internet, and the court struck that down as overbroad. And that more or less leaves us where we are today. So the Comstock Act is still in the books, the Federal Communication Commission is still in place, but the courts are playing a much more important role than they would have back when my story started. So that ensuring any political, the role of the court ensures that any political coalition that might form would have to take into account in the development of its legislation the fact that it will have to defend whatever it does in court, because the courts are going to be players in the game. Now let me turn back to that question of the different ideas that are involved. What I work out in the paper, and I'm going to read part of it now, is a typology of 4 different groups of ideas, I think, about pornography. And these I define as those based on Christian moralism, on liberalism, on neoconservatism, and on feminism. Let me speak of these in turn. The Christian moralists were responsible for the traditional suppression of obscenity, and, as in the case of Comstock, were actually the motive forces behind the statutes and policies. It bears repeating that, not for the crowd here, but since we're on tape, it bears repeating that traditional Christian sexual morality is strict and simple. Sex is listed only within marriage, marriage is intended to be for life, and every act of marital intimacy is to be open to procreation, permitting no artificial contraception and frowning on sexual practices that are not procreative in type. Although the Protestant Reformation brought in acceptance in some denominations of divorce and remarriage in certain limited circumstances, other deviation in Christian moral doctrine is recent, beginning with the allowance of contraception in hardship cases by the Church of England in 1930. Since Christ himself had said in the Sermon on the Mount that everyone who looks at a woman lustfully has already committed adultery with her in his heart, it's evident to Christians that pornography is sinful in itself. The poetry of love merits its own book in the Old Testament, the Song of Songs, which is undeniably erotic in its imagery, however allegorical its interpretation. But the Christian is instructed to live chastely inside marriage and out. Now, Anthony Comstock, who, if the language of American politics were the same in the 19th century as it is in the 21st, could have been described as the porn czar of his era, Comstock spends little time elaborating on Christian teaching concerning these fundamentals, but he clearly draws his inspiration from a Christian sensibility. Let me quote a passage he wrote. "The effect of this cursed business on our youth and society no pen can describe. It breeds lust. Lust defiles the body, debauches the imagination, corrupts the mind, deadens the will, destroys the memory, sears the conscience, hardens the heart, and damns the soul. It unnerves the arm and steals away the elastic step. It robs the soul of manly virtues and imprints upon the minds of the youth visions that throughout life curse the man or woman. Like a panorama, the imagination seems to keep this hated thing before the mind until it wears its way deeper and deeper, plunging the victim into practices that he loathes." Well, except perhaps for the part about the damnation of the soul, the only difference, I think, correct me if I'm wrong, between this and what Norman Doidge gave us yesterday is that he has the chemical pathways to confirm the intuition that Comstock mentions. He's confident in his knowledge of right and wrong in these matters, indignant at those who engage in wrongdoing, and at the liberals who apologize for them. And he's confident in his ability to employ the force and the moral force of government to fight sexual vice. Though a reformer, Comstock's work is not like the abolitionists in imagining a transformed society. Vice might be suppressed, but I don't believe he ever supposed it could be eliminated. But his is the language of vigilance, appealing to a consensus among the righteous and finding it widespread in Protestant America, even in the midst of demographic and social change. Well, neither in temperament nor in occupation is there anything Catholic about Anthony Comstock. The reformers he associated with were all Protestants, and sometimes were involved in the campaign against drink, which was not a Catholic cause. It's particularly interesting, though, that in the control of motion pictures in the early 20th century, there was important Catholic participation. evidence in the Catholic influence on the Hays Code itself, which was prompted by the formation of a Catholic Legion of Decency and drafted by a Jesuit priest, Father Daniel Lord, who was professor of dramatics at St. Louis University and editor of a widely circulated publication for Catholic youth. That code included not only a list of rules covering numerous matters beyond obscenity, but also a list of reasons underlying them, as can be gleaned from this excerpt. I want to read a little to you of this and urge you to Google Hays Code and read the original itself. This is actually in the reasons for the Hays Code. In the Hays Code, approved by the movie industry, law, natural or human, shall not be ridiculed, nor shall sympathy be created for its violation. By natural law is understood the law which is written in the hearts of all mankind, the great underlying principles of right and justice dictated by conscience. By human law is understood the law written by civilized nations. And now here are the reasons given for the rules about the depiction of sex. Out of regard for the sanctity of marriage and the home, the triangle, that is, love of a third party by one already married, needs careful handling. The treatment should not throw sympathy against marriage as an institution. Scenes of passion must be treated with an honest acknowledgement of human nature and its normal reactions. Many scenes cannot be presented without arousing dangerous emotions on the part of the immature, the young, the criminal classes. There follows a recommendation that even pure love not be shown in all its facts, and as for impure love, quote, the love which society has always regarded as wrong and which has been banned by divine law, it must not be shown as attractive, laughable, arousing morbid curiosity, or permissible. As even these brief excerpts make clear, the code did not merely prevent egregious harm, but instead attempted positive moral instruction. The prohibition of vulgarity, obscenity, and profanity is thought not to even need reasons beyond statement of the rules. Well, the second group of ideas are those that one could denote as liberalism. Comstock already does and uses the term. Beginning in earnest in the mid-19th century in England and captured in works such as John Stuart Mill's On Liberty, liberalism would limit government regulation to other regarding actions. And I think that means other affecting, not watching others, but other affecting. And leave individuals as masters of their personal moral opinions and behavior. Although their precise claims were often expressed in muted forms in environments where Christian moralism was widely and deeply influential, liberals held sexual morality to be a private matter and thus called into question social and legal practices that restricted sex to marriage. Moreover, as in Mill's celebrated tract, they made freedom of speech an independent value and thus found censorship of sexual material doubly offensive for imposing upon free expression and squelching sexual freedom. Although the theories of European authors such as Friedrich Nietzsche and Sigmund Freud undercut the ideal of the rational person celebrated by the early liberals, the publication and dissemination of their works served the liberal argument. Their circulation must be allowed for the sake of human freedom, and the sexual knowledge they meant to convey was portrayed as addressing the longing for human happiness. Modernist authors such as George Bernard Shaw, James Joyce, and D.H. Lawrence produced works that attracted the censor's wrath and the critics' acclaim. At the very moment when self-censorship of the film industry was taking place over liberal protest, federal judges began to allow admired literary work to be free from the censor's strictures. The duty of society to prevent harmful speech eventually fell before the liberals' confidence that censorship was generally, maybe always, more harmful than any speech itself could be. The common sense observation that the allure of vice is often enhanced by its suppression, and the observed success of literary productions known to have attracted censorial interest because of that interest, Shaw's play was an example, this seemed to confirm the liberals' argument in favor of free expression. Even if censorship was not wrong in principle, it was futile in practice. So prudence confirmed what prurience sought, the abandonment of restrictions on what could be read or seen. The third cluster of ideas I want to call neoconservatism. As the Supreme Court doctrine enforced permissiveness in the 1960s and as liberalism grew increasingly relativistic in demeanor, a secular case for censorship was made by several authors whom I describe as neoconservatives. They accepted the premises of liberal democracy as the practical basis of the American regime, but they questioned whether the constitutional republic could thrive if the polity showed no concern whatsoever for the character of its citizens. Though students of classical political philosophy, they did not suggest restoring virtue rather than liberty as the end of political life in modern America, but they did argue that a free society depends upon a certain virtue in its citizens, and to that extent, they adopted the language of classical republicanism. They found the recent involvement of the Supreme Court in enforcing a liberal, or rather libertarian, doctrine of free speech that effectively removed all censorship of obscenity. They found this to be doubly problematic in relation to citizen virtue. It permitted material that tended to corrupt those who needed instruction in noble deeds, not base ones, and it took from the people the decision about how to preserve their own liberty and virtue. The neoconservative defense of obscenity was a sophisticated one. Walter Burns, for example, concludes his fine essay on the topic by explaining the value of the obscene in great art, citing as an example Edmund's "Stand up for bastards" speech in Shakespeare's King Lear, showing how artistic use of obscenity serves to ennoble and asserting that art itself thrives in an atmosphere of partial censorship more readily than in a world where everything is permitted and no one publicly cares to distinguish art from trash. Burns is no Comstock, who would brag about how many trainloads of smut he had captured and destroyed in his career. But it's enough for Burns that it be returned under the counter or behind a screen. The fourth set of ideas are those of modern feminism. There were disputes among feminists concerning this, but the idea was formulated most especially through the work of Andrea Dworkin and Catherine MacKinnon. There, the idea was that pornography would be defined as the diminution of women, or as involving the subordination of women and the images that would support that. Well, I'm being short on time. I'm going to mention only not the details or the nuances here, or at least anymore, but simply say in 3 points in conclusion. First is, I think that as we begin to think about what's politically possible in terms of regulation, we keep in mind the constitutional dimension. That means respecting the priority of the states over these matters. That's part of why I like Jerry Bradley's tort-based approach, and also why I like the idea of removing copyright protection, since that's a federally created right, and in fact the only direct relation of the federal government to the culture and to popular culture. A second point is to note that any successful political action is going to require a coalition, and it's going to be a complex one to put together. And finally, I say a few words in the paper and about what I think we can do, not through law, but simply through practice, and that is try to restore some element of modesty to public debate and to what we describe in public. A lack of modesty in describing sexual things, it seems to me, tends to erase the distinction between human beings and animals, to treat ourselves only as bodies, not as persons. But at the same time, the antiquated social practice of Comstockian America, of never publicly discussing sexuality, also disregarded the specific character of human beings, for the sexual act is also animalistic if mute in its anticipation and in its aftermath, if its role in a complete human life cannot be explained. To acknowledge the political difficulty of the situation of those of us who would protect against pornography is to introduce a certain modesty into the discussion of what ought to be done. But the restoration of modesty, not to say awe in the face of sexual passion and power, would be already, I think, a healthy first step.